Alors, bonjour à toutes et à tous. Je suis Miriam Cohen, professeure à la faculté de droit de l'Université de Montréal. Welcome, everybody. Good morning. I'm Miriam Cohen. I'm one of the organizers of the conference that will take place the next 2 days. And the conference is part of a partnership project that I'll be talking to you about in a few minutes. So welcome to the Climate Change and Reparations Conference. We're honored to gather here over the next 2 days to engage in a conversation that is not only timely, but also, as you know, an urgent topic. As the impacts of climate change intensify across the globe, so too the questions of justice, responsibility, and redress. So this conference is dedicated to exploring the most challenging and often under-addressed aspects of climate justice, the timely question of reparations. So I won't take too long because we have a list of stellar speakers, including our keynote speaker. I want to begin by extending my warmest thanks to each and every one of you who has joined in person and online. Your presence speaks to the importance of the topic and your commitment in imagining and advancing new approaches to accountability and global solidarity in terms of reparation. So to our panelists that are joining us in person in Montreal and online, thank you for sharing your time. Thank you for sharing your research and your expertise with us. We're fortunate to benefit from a truly interdisciplinary international group of scholars, practitioners, and activists who will guide us through complex legal, ethical, and policy dimensions of climate reparations. This event would not have been possible without the generous support of the Law Commission of Canada, the Social Sciences and Humanities Research Council of Canada, the Canada Research Chair Program. Thank you so much for your support, which made this gathering possible. Your commitment to fostering impactful dialogue is deeply appreciated. I'd also like to thank the Centre de Recherche en Droit Public, and in particular, Rodrigue, Sylvain, Alma, who helped us with logistical and technical support and all other kinds of support. So thank you so much. Thank you also to the faculty administrators and students whose hard work behind the scenes over the past months has been nothing short of exceptional. And of course, my heartfelt thanks to the incredible colleagues, this organizing team, which envisioned this conference with me. So Dr. Maria Antônia Tigre, who is joining us online from the Sabin Center for Climate Change Law at Columbia Law School. Professor Armando Rocha from Católica Lisbon School of Law, who's also joining us online. Professor Vladyslav Lanovoy, who will be here in any minute from Université Laval, and our wonderful fellows, Camille Martini from Université Laval, that you all know very well, who has communicated with you over the past few weeks. And Olivier Nfago, who's a fellow at my research chair from Université de Montréal, and Éneas Xavier from Université de Montréal as well. So I will give the floor to Camille, who will talk to us briefly about a bit of the logistics organization for the next 2 days before we welcome our keynote speaker.
Thank you so much, Miriam. And thank you for letting me addressing the room a bit. So you all know me, I feel, in the room because I've been exchanging about logistics, and I'm going to continue doing that right now. I wanted, first of all, to thank also the audience joining us online today. We received so many, literally so many abstracts for the conference, which also reflects the great interest and importance of the topic we will cover in the next 2 days. And I want to thank them and thanks people that will join online and share their expertise as well on Zoom. So we have an exciting 2 days ahead. We have 3 panels that we're going to cover today. The first one being on the definitional frameworks and a bit setting the stage about loss and damage and reparations. We'll follow with responsibility under public international law, so continuing defining the frameworks that regulate reparations. And then this afternoon, we'll wrap up the day. We have to finish early, so we'll be tight on the schedule with human rights and reparation. And then tomorrow, same time, we'll have another 3 very exciting panels, starting with case studies in the morning, followed by let's say a panel about looking ahead and how courts can shape reparations. and we'll finish with financing loss and damage and reparations. One might say a very hard topic that I'll have the privilege of moderating, but we'll see that tomorrow. I just want to mention as well very briefly how we're going to function with questions from the audience online. So I will be monitoring the chat, sorry. So if you have questions, feel free to raise them at any time in the chat. And then once we get to the Q&A part of the panel, we'll be able to share them. If you want to take the floor online, you may, but please share your question in the chat so I can give you the floor. And then we ask that you keep your microphones muted and the video off if you can. And then you can obviously take the stage if you want to bring your question online, but we're going to navigate in the classroom and the conference room and online. So please raise your question in the chat and I'll be happy to raise them in due course. Thank you so much. And please enjoy the conference. And now I hand the floor back to Miriam to introduce our keynote speakers for today. Thank you so much.
Thank you, Camille. Great. So we're honored to have two amazing keynote speakers who are specialists in the field who open our conference and enlighten us for the next couple of days. So our first keynote speaker is Lien Vandamme. She is a Geneva-based senior campaigner for CIEL's climate and energy program. She contributes to CIEL's work on human rights and climate change, in particularly related to the loss and damage. She co-facilitates the Human Rights and Climate Change Working Group, convening civil society organizations, indigenous peoples, representatives, and other experts advocating for the promotion and respect of human rights in climate action, and focuses on the UN climate change regime and the implementation of the Paris Agreement. She worked as a policy officer on climate and natural resources for and then the Belgium Coalition of International Solidarity. In that capacity, she executed advocacy campaigns targeting governments and international institutions, coordinated the political work of the Belgian Climate Coalition, and was a member of the Belgian delegation of the UNFCCC. She holds a master's in comparative and international politics from the University of Leuven and a master's in climate studies from Wageningen University. During these studies, she specialized in international climate politics and interned and worked for various NGOs. Thank you so much for joining us online. And I'll introduce also our second keynote speaker, Joie Chowdhury. She's a senior attorney, climate and energy program. She's among her primary areas of focus, she contributes to CIEL's work in support of the advisory opinions on climate change that have been requested from several international tribunals, the International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. Before joining CIEL, she worked at the International Network for Economic, Social, and Cultural Rights. She first joined their strategic litigation program team and then established and coordinated their environment and ESCR program with the leadership of network members. Prior to that, she worked with several organizations and academic institutions on legal research, fact-finding, and advocacy in India, the United States, Kosovo, and Switzerland. And she has taught courses in international human rights law, constitutional law, and climate justice. So it's my utmost pleasure to welcome our keynote speakers who are joining us online, and I'll just...
Yeah, thank you. Big thank you to the organizers for really just for organizing this super interesting session, these 2 days of important discussions, and also, of course, for inviting us, me and Joy, to start off this conversation. I'm really excited to be here. Yeah, I'll start with giving a bit of a scene setting presentation where I will focus on the right to remedy for climate harm under international human rights law. And then Joy will talk more specifically about a case study of how remedy and reparations have transpired in the context of the advisory opinion proceedings on climate in the International Court of Justice. Just to start, my first presentation, the scene setting, is based on a report that we published last year in October or November, really specifically on the topic of remedy and reparations for climate harm from a human rights perspective. And so that will be really the basis of my presentation, and I invite everyone to have a look at the report as well, which of course has much more details than what I can present in these 10 minutes. I will share the link in the chat later on. And I'll start with the human right to remedy and reparations. But before that, of course, it's important that even though I will be focusing on human rights and international human rights law, that we recognize that international human rights law, when looking at remedy, of course, it builds on the law of state responsibility and the basic principle that when a right is violated or when a duty is breached, that the injured party has a right to reparations for any harm that they have endured. And so states have legal duties in the context of a breach of, when they breach their duty, they have the legal duty to cease the wrongful conduct and to redress the harm that they've caused. And so in the context of the climate crisis, because states have known for decades, for well over half a century even, that what the principal causes of the climate crisis are and what the foreseeable consequences of the climate crisis could be, that they have the duty to cease wrongful climate destructive conduct and to redress climate-related harm that they have caused or that they have contributed to. And so under international human rights law, we apply that, of course, to human rights. So states have legal obligations to prevent, minimize, and remedy foreseeable human rights violations from climate harm. And we know, of course, the science has demonstrated, and we have all seen and witnessed that the climate crisis is causing widespread human rights harm across the globe, but also disproportionately in certain countries and for certain communities and for certain groups. And so the people that are harmed by the climate crisis have a right to remedy, including full reparation. And under the UN basic guidelines for remedy, the various forms or types of reparations that are identified are listed here. It's restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And the reason why I'm highlighting that here, and I think the audience of this conference probably knows this very well and knows these various aspects of reparations. But in other contexts where we're talking about loss and damage, where we're not talking about remedy and reparations because it's actually a taboo word to say, for example, in the context of the climate negotiations, we see that how people are interpreting or how people are looking at remedy and reparations, it's very often through the narrow lens of compensation, of monetary compensation. Well, it's clear that there is, of course, much more to actual full reparation, and very often different elements or different buckets of this type of reparation will come together to actually provide meaningful remedy for people that are harmed. And Joie will also go a little bit deeper into the forms of reparation linked to these different categories as they have been presented by states in the context of the ICJ advisory opinion proceedings. So I talked about state obligations, but of course these also extend to corporate conduct and accountability, which on one hand, of course, is about the state duty to regulate the private sector and corporations to, first of all, again, prevent and minimize harm, but also when harm occurs to ensure that the private sector actually remedies that harm. And corporations also have independent duties to do so. And in that context, it's really important, and then I know there will be other speakers talking about it, but it's really important to mention, of course, the polluter pays principle, which goes hand in hand with the right to remedy, and which means in this context that industries that are driving the climate crisis, that they have to cover the cost of the resulting climate harm, which is, of course, something that currently we are not seeing. And what that means in practice in terms of policy measures, in terms of mechanisms that need to be put in place. We're looking at finance mechanisms that really generate resources from the fossil fuel industry, from other polluting industries, to redress climate harm. And there's specific proposals that have been published by civil society, by others, for example, the climate damages tax that really puts a levy on the production of fossil fuels to generate resources to then redress or address loss and damage of affected communities. So that was the legal basis, and so we know that there is the international legal obligations exist. People have the right to remedy for the harm that they are facing in the context of the climate crisis. But then in reality, we see that that remedy is not being provided, and that communities that are currently facing impacts are left usually to pay for it themselves. And that at the moment there is no financial provision, but also no other forms of reparations being provided for these communities. And so when looking at why that is, we find a couple of political obstacles on the road to justice, with, of course, the most important one, the fact that the multilateral climate governance regime, the United Nations Framework Convention on Climate Change, fails to uphold the right to remedy. And in the context of the negotiations, there's even been decades of denial of the need to even address loss and damage as a specific type of measures. There was very long attempts, and actually we still see that coming back from time to time, to put adaptation and loss and damage under the same pillar and saying that these are the same things. And even though we now have a loss and damage fund that was established, which was a really important step in terms of that recognition, we still see that it is the payments to the funds are voluntary, which is leading to it being completely under-resourced. And the agreements that have been made to operationalize a fund up to now have not been aligned with human rights obligations. So again, we're not seeing the UNFCCC actually stepping up to fulfill the right to remedy for people facing climate harm. And I won't go into much detail, but if we want UNFCCC mechanisms to actually play a role there, they need to be deeply restructured. And that's also been recognized by the UN Secretary General in a report that he published last year for the Human Rights Council, where he literally mentions that UNFCCC mechanisms for loss and damage are important, but currently they are not structured or built to actually uphold legal obligations in the context of remedy. So that's really important, I think, to keep in mind when discussing legal and political pathways forward. And then another obstacle, and I'm afraid that I'm going over time, so I won't talk too long about this, but it's an important one, I think, to recognize when we're looking at legal obligations, when we're looking at remedy and reparations from a legal perspective. We can't ignore the deeply unjust and post-colonial economic system that we are currently in, that is causing injustices in various ways, and that, of course, also has led to a situation where climate vulnerable countries are the countries that are in that crisis, in that distress, and that the climate crisis and even climate finance mechanisms are currently reinforcing that injustice. And so that even though legal pathways are critical and really important, we should also keep in mind that we need a truly systemic transformation of the economic and political system to actually address the injustices that we're seeing, and that also means that reparations may encompass that justice. And Joie will also speak a little bit more to that afterwards. So just to finish my part of the presentation, of course, there is the question of, we have the obligations, we have the political obstacles, so we're not seeing obligations being fulfilled. So what are the legal pathways that we can take to advance remedy for climate harm? And so there of course, there's the role of human rights institutions, bodies, mechanisms to look at how existing legal obligations apply in the context of a changing world, where we see that, even though the climate crisis, it's been very clear for a very long time, there is new elements that come in, and it's really important to interpret these legal obligations in that context. And we've seen that for a very, very long time, that the human rights world, so to say, has done that. This is really critical to guide litigation, and of course also to guide global climate governance. To give an example, currently the board of the Loss and Damage Fund is discussing a startup phase for the fund. So really thinking of putting in place early interventions as soon as possible. And ahead of this board meeting, 3 UN special rapporteurs have sent a letter to the board to remind them of their human rights obligations and also giving concrete recommendations of what that means for the startup phase. For example, putting communities in the driver's seat of such a startup phase. So it's really important to interpret these legal obligations in the context of the climate crisis and then feed into litigation and global climate governance. So here I've listed on this slide various institutions that have already done some of that work, and there's much more that to be said. I don't have time to go into all of it. I'll maybe just mention, I already mentioned the study by the UN Secretary General, which was really important. I mentioned the special procedures, and Joie will go into the international courts. So maybe just to focus on the human rights treaty bodies, there's a general comment by the Committee of the Rights of the Child that has looked at the rights of children in the context of climate change and has explicitly made that link between climate-related loss and damage and the right to remedy. And that's really important because then we can continue building on such authoritative statements in the context of litigation and in the context of policy making. And of course, there's much more that can be done there. And I mention it explicitly also because I think it's, again, important to keep these mechanisms and these examples in mind when going into your conversations in the next 2 days on these topics. And then very briefly, but I'll stop there. But of course, there's also the application of the law. There's litigation in the absence of actual political responses, multilateral responses. Litigation is a key tool to enforce existing norms. And again, there I've listed a couple of examples. I won't go into detail now because I think I've already talked too long, but I'll hand it to Joie, who can give much more context on what's been happening in the context of the International Court of Justice, the advisory opinions on climate, and specifically, of course, on reparations there, which is a very important example of these norm setting and also application in the context of the law. So I'll stop there, but I'll stay online to answer any questions later. And Joie, the floor is yours.
Thank you, Lien. Can everyone hear me?
Yes.
Yes.
Okay, well, wonderful, great. Hello, everyone. Thank you also to the organizers. I'm Joie, and it is a pleasure to be here with all of you today. I'm a little bit sick today, so apologies if I start coughing while I speak. I wanted to share with you a quote that reflects to a large extent the kind of transformative reparations we are fighting for. I won't read it out, but I leave it for a minute. But essentially, it isn't just, as Lien mentioned, about compensation. It goes far deeper than that. And this is something we'll discuss as we unpack what is happening before the International Court of Justice. Because to illustrate some of the aspects Lien highlighted, I would like to speak to you today about how the International Court of Justice climate advisory proceedings, which I closely work on, provided a stage or is providing a stage for powerful arguments on the right to remedy and reparations, primarily through the lens of the law of state responsibility. If we could change the slide. So climate justice aligned states at the International Court of Justice have compellingly made the case that the conduct responsible for climate change and its catastrophic, not just climate change, but the climate crisis and its catastrophic consequences is unlawful. And such unlawful conduct, which can be attributable to a state or states, then triggers legal consequences, including cessation of climate destructive conduct, guarantees of non-repetition, and the provision of full reparation. I know Susan and Samuel will be speaking on the ICJ and the link with the negotiations, which I'm excited to hear, so I will not focus in particular on that linkage. Now, to zoom out for a moment, if we could also change the slide, that'd be great. Just to ensure that we're all on the same page regarding the ICJ climate advisory proceedings. Essentially, on 29th March 2023, the UN General Assembly unanimously adopted a resolution requesting the ICJ to give an advisory opinion on the obligations of states in respect of climate change. This resulted from the relentless efforts of Pacific Island students, global campaigners, and the leadership of many states, especially Vanuatu. And what is an advisory opinion? Advisory opinions are not decisions in contentious cases where the court steps in to settle a dispute, but it is where the court is asked its opinion on a legal question on which the court then provides clarification. Advisory opinions are considered authoritative interpretations of international law. And the two defining questions before the court are, what are states' legal obligations to address climate change? And what are the legal consequences for failing to meet these obligations or for breaching these obligations? Now, the high level of participation in these proceedings has been unprecedented. Just to consider the oral phase, 96 states from every region of the world, as well as 11 international organizations, presented oral arguments before the International Court of Justice, including on the specific issue of reparations. And such historic levels of participation throw into stark relief the urgency, the scale, and the devastating impacts of the climate crisis and the need for collective clarity on some of the most critical legal issues of our generations. And reparations was an absolute flashpoint in the ICJ proceedings, providing important insight into how countries all across the world are approaching the issue of reparations from a legal perspective. A strong and progressive advisory opinion from the ICJ clarifying the legal obligations of states, including on remedy and reparations, would contribute significantly to tackling the climate crisis, providing a legal roadmap to protect people and the planet. And this may help break the deadlock we see today of major polluters continuing to do their utmost to evade and dilute their legal duties and deny redress, while states are facing the threat of disappearing altogether, and individuals and communities are facing devastating human rights harm. Accountability is central to a climate justice approach. It is beyond time to halt the cycle of continuing harm and inaction. Reparations for climate damage are a matter of obligation, not charity. If we could change the slide, please. So what did big polluters argue in the proceedings? What was interesting is that major emitters attacked the foundations for remedy and reparations for climate harms through several strategies. And these multiplicity of pathways with which polluters are aiming to block the legal right to remedy and reparation is very well worth paying attention to, because these are not new arguments. These have and will continue to come up in courts, in negotiations, and in legislative fights. One of the major arguments centered on narrowing the applicable law or the governing law in relation to climate change to just the climate treaties, rather than the entire spectrum of relevant international law, to continue to narrow it just to climate treaties, especially the Paris Agreement, and then misleadingly assert that the climate regime displaces the law of state responsibility and other relevant legal norms. Some climate-destructive states even appeared to assert that international cooperation under the climate regime substitutes for legal consequences, despite decades of multilateral efforts failing to provide meaningful redress for those most affected. For example, according to Kuwait, the climate regime, UNFCCC, Kyoto Protocol, and the Paris Agreement establishes a set of specialized rules to the exclusion of other norms, basically your lex specialis, which precludes application of the rules of state responsibility. Along similar lines, the United States made clear that in their arguments that they believe neither the UNFCCC nor the Paris Agreement contains rules regarding state liability for adverse effects of human-induced climate change, and instead points to the regime's cooperative, facilitative, and serious approach to loss and damage associated with the adverse effects of climate change. I'm air quoting serious approach because, as Lien has mentioned, the UNFCCC space has been completely insufficient so far in addressing loss and damage in a meaningful way. Considered closely, the arguments of the United States in the ICJ proceedings essentially denies the relevance of obligations long predating the climate regime and would lead to a legal vacuum in terms of historical responsibility. To the extent that the law of state responsibility is considered to apply, some polluters have focused on the elements to establish an internationally wrongful act. So basically breach and attribution, which is required. You need to establish this internationally wrongful act to then trigger legal consequences. So they're focusing on elements and are trying to block the establishing at all an internationally wrongful act. So basically their arguments have been that breach cannot be made out at all. There is no breach either because the relevant international obligation is inapplicable or has not been breached, or because the relevant conduct is not attributable to an individual state, or that climate-related harm cannot be linked to relevant conduct. They advance a wide range of arguments in support of this position, including lack of sufficient knowledge of the causes and foreseeable consequences of climate change in the past to have triggered preventive duties, purported scientific uncertainties, making causality analysis more difficult, and the alleged complexity of singling out specific states when multiple states have contributed to climate harm. So if we could change the slide. Yes, just one more. In sharp contrast and in line with what climate justice requires, a majority of states have argued that the conduct leading to devastating climate, so these are states that are taking more climate justice aligned positions, and they have argued that the conduct leading to devastating climate harm was and is in breach of obligations under multiple sources of international law. They've argued that attribution barriers are not insurmountable and that the law of state responsibility applies, triggering legal consequences. Vanuatu clearly set forth the overarching framework governing legal consequences as rules of general international law codified in the Articles on the Responsibility of States for Internationally Wrongful Act. Such consequences entail cessation, non-repetition, and reparation, reparation encompassing restitution, compensation, and satisfaction. The DRC, alongside many other states, refuted major polluters' arguments, emphasizing that the UNFCCC and the agreements concluded under it do not relieve states of responsibility under general rules of international law, as noted in the various statements made by Pacific states when becoming parties to the Paris Agreement. In relation to these declarations, it is significant that one of the judge's questions at the end of the orals specifically asked about the significance of these declarations. These questions from the judges provide a glimpse into what judges consider as key issues at the core of the case. If we could go to the next slide. So when legal consequences are triggered, as many states have argued, are triggered under the law of state responsibility. And when I say many states, these are 70 plus states that we're looking at from all regions of the world, not, the North American region necessarily. What do these forms of reparation look like? Now, several states have elaborated on forms of remedy, including comprehensive structural redress that is vital to providing remedy beyond compensation and for both material and non-economic harm. Among proposed measures to ensure cessation of harmful conduct and guarantees of non-repetition, Vanuatu includes stopping fossil fuel subsidies and undertaking deep and rapid emission reductions. Colombia considers guarantees of non-repetition should entail formally committing to timelines for decarbonizing their economies and phasing out fossil fuels while adopting and enforcing regulations for their private sector. States such as Kiribati, for example, have also stressed that the duty of cessation requires urgent, genuine, and substantive action to cease harmful emissions rather than relying on what many would consider false solutions, which can aggravate harm, such as geoengineering. States made clear that reparation is not just about monetary compensation, but also systemic measures, for instance, support for adaptive adaptive capacity, non-monetary redress for human mobility, including displacement and migration, ecosystem restoration, tributes to victims, the recognition of territories and maritime spaces of ocean states and their continued statehood and sovereignty, despite losing territory to rising sea levels, restoring the rights of indigenous peoples to their lands, territories, and resources affected by climate change, and several countries argued for debt cancellation and relief. That these different types of measures, which for countries in varied contexts would translate into meaningful remedies, surfaced in the way that they did at the ICJ. This is really important because, yes, the pathway to concretely securing remedy can be through courts, but also through other pathways such as multilateral arrangements, legislative fights. And notably, there were multiple submissions to the Cook, such as from there were multiple submissions to the court, such as from Cook Islands, which connected colonial legacies with how climate devastation is experienced. And this was then reflected in calls for specific reparatory measures, including debt justice. Now, we hope, of course, that the ICJ confirms that climate destructive conduct triggers legal consequences under international law. This would be particularly significant as the issue of legal consequences has not been sufficiently considered yet in legal contexts. In this era of devastating and escalating climate harm, clarification of the law by the ICJ could lay stronger foundations for climate reparations. Regardless of the outcome, the proceedings themselves have provided a treasure trove of legal arguments for climate reparations to build on in litigation, negotiations, campaigns, and regional cooperative efforts. And for those of you interested in this interconnection of reparations and the law, I very much encourage you to read the country submissions. It's all available on the ICJ website. And finally, to end, if you could go to the last slide. A few brief reflections to consider in the climate reparations context, especially with respect to litigation and not tied just to the ICJ proceedings, but broader in scope. International law must be transformed to better support climate justice. Many of you would be very familiar with these discussions because many of us have them all the time. And this would include decolonizing legal principles and easing procedural barriers that block access to courts. We also must look beyond traditional legal pathways. Yes, strategic litigation can importantly affirm the right to remedy and reparation and provide concrete redress in specific contexts, but we need to be very clear-eyed in our strategy of how we can effectively unlock the kind of financial flows that we need, which are in the trillions, and deliver transformative reparatory measures for climate justice. Where is the role of law and litigation in these broader political movements for systems change? That is something for us to consider very deeply as a collective. And then lastly, there is South-South solidarity. This was powerfully reflected in the ICJ climate proceedings and may hold the potential to challenge existing power dynamics and contribute to ushering in a new era of multilateralism, offering new leverage points such as sweeping tax reforms, debt-related pushback, large-scale funding mechanisms predicated on state responsibility. And in the face of deepening climate devastation, this may hold the potential to drive transformative redress and reparatory justice. So I'll end here. I'm excited that we will be delving deep into climate reparations discussions these next 2 days, and it is an honor to be here with all of you. Thank you.
Thank you so much for such insightful keynote speeches. I think it sets up the 2 days ahead and the main points of discussions. We have a bit of time for questions, so I wanted to invite you all, if you have any questions for our keynote speakers online or in the room.
Even though remotely to our conference. And I was just, as you were speaking, I could realize how difficult it is to navigate in these sort of concentric circles, in the sense that you have negotiations happening at the same time as the law sort of evolving, and we are expecting clarification and who knows, even some level of development through interpretation, through evolutive interpretation of some of the instruments. So I wonder how much really cross-cutting conversation there is, in the sense of, in the ongoing negotiations, how much states, the same states, pick up on the same points that they lay out in these different, before these different courts and tribunals, and vice versa. Is that happening, or is there much less sort of reliance on the law in the context of negotiations as such? And the priority is much more on, hey, there is an engagement. We need more to emphasize the needs for developing countries to adjust, and rather than picking so much on the law. So that the question is how much of really close interaction there is, how much of those legal arguments really get hold in the negotiation room these days in different COPs that you have followed.
Well, I mean, it's a really interesting and important question, because I mean, it's really pointing to the problem, right? Because the reality is that no, in the UNFCCC, there is not, like, for example, talking about like human rights obligations, there's a lot happening in the context of the human rights mechanisms. There's there really you can see also states engaging very strongly on how human rights obligations apply in the context of climate change. But then when we go to the UNFCCC, to the negotiations, that's much more difficult. And what we see is that when human rights are being mentioned in the context of the UNFCCC, it is very often, and importantly so, it's in the context of ensuring inclusivity, ensuring equality. So there's there's a gender action plan. There are some, there is some progress that has been made in ensuring that climate action is human rights based and that it's inclusive. But much less so in the context of like the obligations that are related to that. And for example, in the context of the climate finance discussions that we had at COP29, where states were basically discussing a new climate finance goal to replace the one that we had, a very old one from 2009, to provide 100 billion per year. That was too low and was never achieved. So there were discussions on replacing that one last year at COP, and there, the obligations that states have to actually provide finance that is up to the scale of the needs of communities in developing countries, and to make sure that that finance is, grants based, so it doesn't exacerbate that, which is also detrimental for human rights. Making sure that the finance that is provided is community-led and not being, provided through multilateral development banks that have a bad track record when it comes to, respecting human rights in the context of implementation of activities. When we're talking about all of those things, all of a sudden those states that are, outspoken on human rights in other fora, they don't speak up, and they avoid their legal obligations in that context. And so I would say that one of the big problems of at least the UNFCCC as a space is that it is much more about avoiding legal obligations than about implementing and upholding them. And so that's where, and I'll give the floor to Joy, that's where this International Court of Justice advisory opinion is going to be critical, because it's, it has forced states to come out and say what it is that they're not saying in the UNFCCC. So even like, regardless of what this advisory opinion is going to be, the arguments that states have made in the court are already really important to, hold them to their legal obligations, and to also, in some cases, also expose, what they're doing and what they've been trying to do in the context of UNFCCC. So yeah, I'll stop there and give it to Joy for additional thoughts.
Thanks, Lien, and thank you for the questions. I realize you don't have a lot of time, so I'm going to try to keep the responses brief. But I think the questions were about the concentric circles, and it's exactly that, right? Like if you look at the arguments of many global South countries before the court, it was a huge frustration with the multilateral system that they have engaged with meaningfully for over 30 years with COPs. and which has failed to deliver. And there are often legal sticking points there, where countries seek to come back to the table and discuss legal issues as if they're going back to first principles, without recognizing that we have long-standing legal obligations that apply in certain contexts, and that there is no need to kind of relitigate. The UNFCCC is not some kind of siloed off space. The agreements have not been written like that, but there is this constant these constant legal blockages. So one of the reasons that, and states speak of this very openly, is that we need further clarity on the law to be able to ease some of these negotiations, to be able to ease some of these very charged discussions that happen in these spaces. So I do expect that, of course, it'll depend on the outcome, which none of us can really foretell, but I really expect that with more clarity, it will give more tools for negotiators to have discussions that aren't held up by these continuous relitigation of what should be very clear views on the law. And it's very interesting. I mentioned very briefly that there were questions posed by the judges of the ICJ at the end of the orals. There were only 4 questions, and it's interesting that 2 of them had to do with the climate treaties. One of them talks about what is the substance of the declaration, because a number of states made declarations when they were becoming parties to Paris, being like, what they're signing on today does not, derogate from long-standing principles of the law of state responsibility and other general principles of international law. So it's interesting that one of the quite progressive judges asks about what is actually the significance of those declarations. And this is one of the sticking points I was mentioning. And another actually mentioned what is the significance, what is the legal scope and content of NDCs, of nationally determined contributions, because this is also hugely in question. Many states have argued that NDCs basically require them to do very little. And one state actually came and argued showing up at COPs is, fulfilling their duty to due diligence, and that NDCs don't have much. They just have to be written and submitted. They don't have much content to them. And it is kind of just a tick box exercise. And this is something that it would be really interesting to see how the ICJ comes back and responds to. But yes, there are many layers of connections. So it'd be really interesting to see. And I think Susan is going to, in her presentation, talk a bit more about these connections. And then I see this very interesting question from Samuel in the chat, which is about decolonizing legal principles and kind of concrete ways to do that. And I don't think we'll have the time to go deep into it. These are very, very complex legal discussions, but just in practical legal terms, one of the big discussions right now is about indigenous and traditional knowledge and really integrating that into litigation in more meaningful ways. The right to self-determination, which is very, very key for indigenous peoples, was brought up very strongly before the ICJ. And that is something that usually, it's the first one in the 2 major human rights treaties, the right to self-determination, but usually states just shut down when we try to speak about the right to self-determination for many different reasons. But this principle, the right to self-determination, it was so powerfully argued by states that, both in terms of indigenous peoples, but also the right of states to their self-determination, and not to have decisions being made very far away from their lands completely upend the way that those countries are able to make their social, political, and economic decisions. A big part of decolonizing legal principles are also tied up with how inequitable the international financial infrastructure is. Loan conditionalities, debt that countries need to take after climate devastation that occurs because of a crisis they had very little hand in creating. And yet many countries in the global south have to pay 14% more interest on loans, for example, than global north countries, which absolutely upends their ability to address the climate crisis. So that is a huge discussion. ISDS, how austerity can be addressed. So there is a lot there, but I'll leave it here for now. Thank you.
We'll sort this out for the next.
Thank you so much for the presentation. I was just thinking that maybe we can have this discussion with detached from what is happening right now, in the sense that the political and legal reality is also challenging in terms of having a country like the US basically pulling out of the Paris Agreement, also rolling back domestic regulations and measures that sought to address climate change and emissions within the US. I'm just wondering whether you think that can create a ripple effect or a domino effect, that all those discussions and to a certain extent progress that have been made may be like rolled back because many countries might disengage because of the current context and the current political climate, and how much damage that can cause in the long term. If you have any comments on that. Thank you.
Sure, absolutely. And just to mention to folks that Lien just mentioned that her battery died, which is why she dropped off, but she'll be back. Absolutely, many of us are really grappling with this question of, you know, what the current kind of flux in geopolitics means and the ripple effects. We are seeing ripple effects because of, you know, developments in the US, for example. We have seen a move to, you know, a great rise in military budgets across Europe. And because of this, there will absolutely be repercussions on climate finance. But I also think it is an opportunity that, you know, this is part of the decolonization conversation that, you know, that many of us have been having over the years, but about delinking, about creating multilateralism or reshaping multilateralism in a way, because I don't think, you know, pulling back, you might see some of that from some countries temporarily, but the US has withdrawn from the Paris Agreement in the past. The US is one part of the system. It is not the system. And I think this gives us the time and the space to think through what is the best way to respond, because in response to what is happening now, the antidote to that is not pulling back. It is to lean into the rule of law, into a progressive interpretation of the rule of law, because we saw after World War II, when we saw many of the international systems come into place, what it means not to have a specific way of settling disputes. The other way, if there is pullback, is just unfettered hegemonic power. And we cannot allow that to happen. There's too much at stake. It is existential, the stake. So I think now is the time to really come together as a collective. Now is time for South-South solidarity to really take place. And all of it is very complex. This is not at all to romanticize the situation or to say that it is not complex, but it is a time for all of the lawyers and the campaigners in the room, the human rights folks, the climate folks, to not lose hope, but to really lean in and to really continue the fight. So I'll leave it here. Lien, the question, I know your battery died, was about, you know, given the developments in the US, are we expecting a ripple effect and corresponding, you know, what does it mean for the climate space?
So, thank you so much. It's for me to thank you both again for such insightful keynote speeches, but also your answers to the questions in the room. I know there were some questions in the chat. I think, Joy, you answered one of the questions in the chat already. So thank you so much again. Very insightful. And I hope you can stay with us, you know, in the panels during the day today and tomorrow. So we'll have just a very short break, just so that we can get the first panel set up. If you haven't got coffee yet, please get some coffee and some fruits, and you know, top up if you're already had some coffee, and we'll be back in literally 2 minutes.